Good afternoon. Today is Sunday the 9th of July 2017 at 5:31 p.m. and I'm just going to do a broad outline of our Memorandum of Submissions in support of a Notice of Application for Leave to Appeal to the Supreme Court in relation to crew who worked on Oyang vessels in New Zealand who are forced labour and are seeking their wages to be paid out of a forfeited vessel, Oyang 75, that they didn't work on but belonged to their employer that was forfeited in New Zealand for Fisheries Act offences. My clients either worked on Oyang 77, that's an old rusty rust bucket that's not worth a lot of money, or on another vessel, Oyang 70, that's sunk. And we had success in the High Court judgment where Justice Davidson said that they could apply for Oyang 75, which is worth about $8 million US, which is about $9 million or so New Zealand, to claim their unpaid wages, which would enable us to apply to have that sold once the court was satisfied about the wages amount that it was unpaid, and if they decided it would cause a manifest justice if that interest wasn't satisfied. So the Sajo Oyang Corporation, who's a competing competitor in the applications under Section 256 of the Fisheries Act, also seeking what they call redemption of their vessel that was forfeited for fishing crimes, so they'd like it back, and they're fighting us. And the person or party that has the control of the vessels that are forfeited is the New Zealand Crown in the form of the Ministry of Primary Industries, which is the government department in charge of fishing. The Supreme Court rules state that we cannot file submissions more than 10 pages long. So that's really our issue where we're at today. When I dictated the submissions, I was at 22 pages, and that was on Thursday, and we've been editing it down, and as of 5 o'clock in the morning this morning, we had it down to 14 pages, and it's getting a little bit tight with what fluff, if there's any fluff to come out, because it's a fluffy submission. So I'm going to read out the draft to see if that helps me to ascertain parts that can be cut out, because sometimes it helps identify anything that's repetitive. There's three main grounds that has to be considered in an application for leave to appeal, and so some of those things overlap a little bit. So first of all, I will have to address in Section 6 submissions on the grounds of general importance. Then in Section 7, I have to make submissions on the matter of public importance, because you either have to have a matter of general importance or public importance to get leave to appeal to our highest court in New Zealand, which is the Supreme Court. And the other aspect that the Supreme Court can consider to get leave granted is if there would be a miscarriage of justice if leave's not granted. But this has to be a really serious miscarriage of justice. It has to be a really patent error that if they don't correct it, it's going to cause a miscarriage of justice wider than just the little parties involved in a dispute. It has to be a really big deal. And then another ground that you can have to get grounds for leave to appeal is if it's a matter of general commercial significance. But that can't just be affecting the parties. It's more if it's a national issue. So I'm going to go through. I set out the submissions, and there is 11 sections. The first section is the introduction. The second is background and the narrative of facts. The fourth section is questions of law and issue raised in the proposed appeal. And the fifth section is statutory interpretation of Section 2561 of the Fisheries Act in 1986 and the importance of context. And Section 6 looks at submissions on grounds of general importance. Section 7 has submissions on public importance grounds. Section 8 has submissions on whether substantial miscarriage of justice may occur if leave is not granted. Section 9 sets out submissions on general commercial significance. And Section 10 has some final concluding submissions as to why leave to appeal should be granted. And Section 11 deals with the issues of costs, because you have to say what the position should be about costs should you win or lose the appeal, and we have to also list our preferred dates for hearing, which really involves advising the court what dates were not available to go. So that is the 11 sections, currently at 14 pages. you're not allowed 14 pages, so I have to get it to 10 pages. So that's what I'm working on today, and I would like to thank my assistants for helping me, and I had a lot of assistance yesterday from till quite late in the morning, 5 o'clock in the morning, from Joanna, our law student, who was helping me with the typing to cut some paragraphs and take out, things. And so we've been working on that, and she's coming in shortly, and so I will do another video to go through the appeal submissions with you, and I thank you for your attention and your support.